Our next case is Lily Thomas versus Union of India 2013. This case also deals with election law and holds major importance in the context of electoral reforms in India that has happened over the years and making it an essential topic within the CLAT syllabus. Now we've dealt with already one case, which is the ADR versus ECI case 2024 in our election law field, but we also will deal with this case today so that you can follow it up and you can keep it in your mind. And one part of your syllabus, you're already done with two landmark judgments. Now, Lily Thomas was a renowned lawyer known for filing several cases, right, before the Supreme Court and High Courts for seeking improvements and changes in the existing laws. Now, because of her legal interventions, a lot of improvements were made in the system because she filed petitions for those, such as disqualifying convicted politicians from contesting elections, introducing a new marriage law also, and was strengthening legal safeguards for legislators. So she was a very important and very, renowned Indian lawyer. On one of her most notable contributions was her appeal that resulted in significant changes in Representation of the People Act. Now, changes to the RPA was very important. We have already talked on this topic before, but if you don't recall, you can look back at our previous videos. In a related development, the Supreme Court of India, in People's Union for Civil Liberties versus Union of India, recognized negative voting as a fundamental right. Now, voting, you must know that voting is a fundamental right for every citizen of India, right? But negative voting also is important, and a person who wants to not select any of the parties and express that is also entitled to their opinion and entitled to their right. That is why the government provided nota, which is none of the above option in electronic voting machines. If you don't like any of the candidates, if none of the candidates fall within your criteria of holding that position, then you can also select none of the above, uh, a button as well on the EVM machine. Here on 10th July 2013, the Supreme Court of India, while deciding this case, along with another case, the name of the case is Lok Prahari versus Union of India, held that MPs, any MPs, MLAs, or MLCs convicted on offense who are convicted by a court of law of any offense and sentenced to at least 2 years or above years of imprisonment would automatically lose the seat in the legislature from the moment of conviction. So, only those MP, MLAs, or MLCs who have been convicted for at least 2 years would automatically lose their seats in their position from the moment the conviction was passed. So this was a judgment that had been passed before. In this case, the court struck down Section 8(4) of the Representation of People Act, which earlier allowed convicted lawmakers a grace period of at least 3 months to file an appeal in a higher court. So those 3 months were provided before this case, before this case came, before this judgment came, that you are provided 3 months grace period, and if you appeal to the higher court and continue in office, if the stay was granted to you, then you can continue with your position. So this grace period, this uh, compensation, this consideration to the convicted felons was also given. So, which was correctly, obviously not right, and which was not fair to the citizens of India as well. So, this landmark judgment had wide ranging consequences, directly affecting nearly 5,000 elected representatives. As per the ruling, all whether elected or not elected or nominated, stand disqualified immediately upon conviction. This is a landmark judgment. Now, we have dealt with recent developments and judgments before this case. But from this case, we are talking about some landmark judgments which are not necessarily decided in the past few years. Maybe they are a little bit older than that, but they hold, if not equal, but more importance in the CLAT papers because again and again they are referred to. So here, please understand what the case talks about. Here, a change was seen from convicted legislators to be allowed in the office from that phase to the phase where upon conviction where the conviction was for at least 2 years, upon that passing of the conviction, the MPs MLAs or MLCs were removed from their seat and automatically would lose their seat. Right? Now, moving on, what happened later on because of this judgment? The Election Commission of India currently has the power to suspend the recognition of political parties. But you know what should be done as well? We should also talk about how improvements can be made. So these are few things that should be done, that should be considered by ECI. It should also be vested with the authority to deregister parties altogether. Deregistration of parties, not allowing the parties to be participating in the process, should also be a power vested within the ECI, so that the it acts as a strong deterrent for the parties before committing any crimes or before taking participation from people, from contestants who are clearly not valid or who have charge sheets pending or who have cases against them already filed. So these will help the parties to not taking them as contestants in the future, right? To address deeper structural issues, it is necessary to allow candidates and parties to raise and spend funds, the state funds, the funds given by the ECI in a transparent and lawful manner. Additionally, introducing state funding of elections could help curb the influence of black money and reduce misuse of muscle power during campaigns. So, because if there are transparent funds that have been given, that have been approved, and they are being used in a very transparent manner, black money, the use of black money will not come into the question. It will be reduced significantly and consequently eliminated from the whole electoral campaigns, and muscle power will also be reduced to a significant amount. It must also be noted that a large proportion of India's voters reside in rural areas. So, a lot of rural areas comprise India, right? So, India is comprised of a lot of rural areas more than the urban regions. That is why it is important that legal awareness, electoral awareness, and voter awareness is imparted to those areas. And they need to understand that. Candidates' criminal background is essential to their being elected in the process, and how criminal background should be given more emphasis. Because right now in the villages of India, the reality is much different. Even though people know about a candidate's criminal background, they give them votes, which is not in the interest of the country. Finally, empowering registered voters in a constituency with the right to recall underperforming MPs would not only strengthen the accountability but also promote greater awareness at grassroots levels. So, right to recall underperforming MPs. What does this mean? This means that right to question the MPs who are not performing well, right to recall their votes. These rights should be present so that the performance is always being evaluated. It promotes greater awareness from the down level, from the grassroots level, which is why this practice should be done.